and I have the honor of moderating this discussion. And I mean, if we go take a step back, crypto assets in crypto assets in insolvency. Before we get into the weeds of everything, what I would like to do is give every one of you a chance to quickly introduce yourselves and what your major connection to crypto assets in academia and practice really is. Would you like to start?
Yeah, thank you so much. My name is Christian Koller. I'm a professor of European and international law at the University of Vienna. And how I got in contact with this subject was actually when Matthias first proposed that we should look further into crypto assets. And we then broadened the subject because there's so much out there in the digital world that is relevant from the perspective of insolvency and enforcement proceedings. And we very quickly discovered that many of those issues have only been addressed very briefly, and we thought this is the point in time we should start about thinking about these topics more thoroughly, and how the idea of the conference and then later the book came around. And I'm very happy that finally we have a book, which is a starting point, but there are still many issues that we need to address in the future.
Mm-hmm. Matthias, would you like to continue?
Yes, so my name is Matthias Lehmann. I'm a professor at the University of Vienna, and I have two fields of expertise where I work most. One is an arcane field called private international law, conflict of laws, where we talk about which law applies, and the other is financial instruments, securities, so shares, bonds, and so on. That was my academic pedigree. And now comes crypto, and it combines somehow both in a very fascinating way, because it's an asset that's basically global in nature, cannot be fixed, is not connected to any particular state. So it raises all of these questions, which law is applicable all the time, I think. So I've, for that reason, I've given a lecture at the Hague Academy of International Law on precisely these questions for 1 week in The Hague 2 years ago, which now will also appear in English. It's already out in French. Then we did a comparative study of the rules on cryptocurrencies, public and private, 25 nations around the world for the International Academy of Comparative Law. And now this book, I think it's the one of perhaps the most fascinating, because it combines the academic issues with the practical issues, and I think that's exactly where we are here, and what Philipp Bohrn so nicely illustrated, how it actually works in practice. That's something you cannot just study from university. You need to hear from the practitioners, and that's why I'm so happy to be here.
Philipp Bohrn, I'm since now 7 years at Bitpanda. I had contact with the industry a while back, also in my old function in the Chamber of Commerce. But even when I started there 7 years ago, there were like sometimes police requests coming in, and but there was nobody kind of really structured building that up. But now, well, over the years, we then started to really have a department that's actually only doing that, getting all these requests and kind of working with the enforcements in there. And I was happy to lead them, and I really liked the way of basically how we are able to support either the police or the clients in finding their, it's a little detective work basically, and it has a lot of to do of educating everybody about the possibilities, because in the traditional world we usually know kind of how things are done and the police are the biggest experts, but here suddenly they're in a field where we are bigger experts.
Okay, then perhaps let me conclude the introduction round. My name is Oliver Völkel. I'm a partner here at CERHA HEMPEL. I'm an attorney at law here in the Vienna city center, and I'm have a love for crypto asset law, if you will. I've I've advised on so many projects crypto-related since 10 years, beginning with coin splits and the introduction of new crypto blockchains back in 2015, wave of ICOs 2016, 2017, CASP applications, protocols, layer 1 protocols, mining farms, staking providers, you name it. So I do have a lot of interest in this particular field of law. And interestingly enough, insolvency and enforcement is something that, although in practice really, really relevant, is not something that comes up regularly. So indeed, it's I have written a chapter also in this book, and it gave me an opportunity to think about these aspects of the law in new ways. Usually you don't look at this from an enforcement and insolvency point of view. And Philipp, I would like to start the discussion with a question to you. Since Bitpanda is a crypto broker, but you're also a securities broker, so you kind of see both worlds. And what would you say is what are the biggest differences in those two worlds? And I mean, if you can, then get into enforcement also a little bit, it would obviously be also amazing. But what's the two big difference? What's the differences in these two worlds?
I think, there are a couple of differences. The one is, of course, the factical ownership. So, like when you look at the classical world, we have usually they are at Clearstream, and so we have this one central bank partner, and suddenly we have an asset that everybody can transfer to anybody, and it can be in a little stick, it can be on a code somewhere. Basically, you suddenly have a physical presence to something that we were in the last decades. The time before, we did have actually physical presence of the security sectors, but we weren't used to that anymore. And even those were now more varied in how the access code looks like. Again, it can be in so many different forms, which for coming back to enforcement means that finding them, identifying them is the first thing everybody needs to understand, that what they are looking for is not the same what they were looking in the past. And then also in how you are able to liquidate them is a huge difference, because until MiCA we didn't have a real licensed regime where somebody could go and say, okay, let's sell it. You could go to Bitpanda, which would be, of course, the right choice. But what would make it the right choice? Is it because we have a lot of AML registration? So yes, we do AML, but are we trustworthy? So yes, we are always trustworthy, but it still is a thing that makes it more and more difficult from that perspective. And then last but not least, and I think there are too many, and you can just add on if you want to. For me, it is in the way of how people perceive the asset, and because. When you take the classical assets, for everybody it's clear, okay, that's there and it makes sense and it has that kind of value, it's understood. But in this, we have a lot of people who just don't have any clue what it means. And that in enforcement means you have to, with whoever you work, you first need to look at how far does he understand what you're talking about.
Yeah. Christian, Matthias, I would like to give you the opportunity to just also add on, so you don't need to wait for questions from my end to keep continuing if you like.
Thank you so much. I think what Philipp just said perfectly underlines, when you look at assets from the perspective of insolvency and investors, of course you want some sort of security, which again then creates trust. And I think this is what Bitpanda does. Is very admirable when you compare it to all the scandals that have been out there worldwide, that for a certain category of assets you have to create trusts for investors to be attracted to these investments. When you look at it from the perspective of Austrian law, what is very interesting, at least from enforcement and insolvency law, that the legislator at the enforcement stage tried to be very innovative and adopt a specific provision that deals with the enforcement, which is, of course, in its nitty-gritties difficult to apply, but they showed awareness that there is this new category of asset out there. On the other hand, they forgot entirely about insolvency. There is no specific provision in insolvency law, and one of which would be very important is the information you alluded to. As an insolvency trustee, you have to have the possibility to contact custodians and require information. And there has been a provision in the Insolvency Act previously, not dealing with the digital assets as such, but that could be interpreted broadly as a basis for the insolvency trustee to ask for information. Interestingly, just that provision was struck from the code some years ago. So now there is a lacuna with regard to the insolvency scenario, but there are provisions with regard to the enforcement scenario. So this is somehow strange in a way. And the reason why they adopted a specific provision for the Enforcement Act was a very funny one. Back at the time, I was still at the University of Innsbruck, and a colleague of mine, he decided to write a comment on the draft bill for the new Enforcement Act. And we were chatting in the hallway, and there was a younger assistant passing by, and we were talking about there are these new crypto, what is that? And she said, I just wrote an article in a German publication about enforcement in crypto assets. And then the colleague of mine said, well, I have to include that into my statement to the draft bill. And this, of course, then provoked the legislator to add one sentence to this catch-it-all clause, which is a funny coincidence, but wasn't really thought through in its entire effects on enforcement and insolvency in general.
Thanks for the great question. So similarities, differences between the asset classes. Now, I will take this from now a scientific perspective. So when it comes to securities, shares and bonds, well, you could always have them in different shapes and forms. You could have them on paper, printed on paper, and then we had dematerialized securities that were centrally stored electronically somewhere. With a CSD, Central Securities Depository, and now you can also store them on the blockchain. And you may say, like, functionally, these are still securities, still shares and bonds, and many of the principles apply. And together with Fabian Schiener, who is here, I've also written an article, like how the rules of securities law apply simply to these assets. And it doesn't matter whether they're stored on blockchain or not. But when it comes to the private law questions, then there are a lot of differences. Because these assets are, although they are individual, they are intangible. And it's very difficult to use the rules that we have for tangible assets for these. You can, of course, try to analogize everything and say, well, the use of the private key and triggering of the transfer is like transfer of possession. But then at a certain point, it becomes very abstract and you don't know what you're talking about. So I think what's so fascinating is, although they can exercise the same functions and fulfill the same functions, the differences in the supporting technology can make legal differences at some points, and we have to find out much better where are exactly these points and where can we use old rules and where do we have to invent new rules. And I'm constantly on the search for, commonalities, differences, and you could draw up a nice table on this, but I was struck by the fact that you said for the intermediary it's also different. I would have thought for intermediaries, you have to treat them differently, but for us, everything that's with an intermediary okay, that's the business of the intermediary. So, you know, the law of the intermediary applies, and I could even think that is like an intermediated asset, right? But you said you have to treat it differently, and I completely understand that that's also the case. So I think we have to paint a picture, and it's not yet complete. So we're working on it.
Mm-hmm.
Please, but just to add to that, because you're quite right. I think two aspects I would like to add there is, first of all, the client has a choice if he needs a custodian or not. So that's a huge difference. So for us, if somebody buys an asset for us, we can be his custodian, or he can just take it and be himself as custodian. And the second huge difference is coming back to how actually the exchange trading platforms actually work. So in the classical world, interestingly, that's a very trust-based system. So when you are a member of an exchange, then basically you have somewhere little money over there, but you do a lot of kind of contract trading, and you don't have to have them at all. But here, in the crypto world, you have to have all the assets you buy and you sell, because no exchange out there is going to just do it because you say, oh, I have 10 Bitcoins, or I have the money to buy that Bitcoins. They say, you give me that, and then I will do the trade. And this is a huge difference, and which I find, and that's why especially our PTS products working with the banks are so successful, is because the banks come up and find two things that they are not understanding. That's the first AML topics. And the second is how these exchanges work together, because they usually say, okay, we make business, and then in some time we settle. And then they come to a crypto exchange and they say, no, money? No? And then we do business.
Yeah. That's a very, very good point, because I mean, MiCA, the European markets in crypto assets regulation, prevents you from using customers' assets and loaning them out, for example. You can't just, unlike a bank who can take deposits and then loan out the money that they receive to, people who would like to obtain a loan. You cannot do that as a custodian with crypto assets. And this is really a paradigm shift. And I think, I'm curious whether you think this has something to do with, with the fact that I cannot simply generate out of thin air new Bitcoins, whereas I can do that with money. I can go to the central bank, sell them my bonds, and all of a sudden I have new money in my in my economy. So what do you think is the reason for this fundamental different treatment between crypto assets and money and other assets? You have an idea on that?
Well, in my previous slide, I was working a lot on this, post-trade world. So this means all the transactions that were concluded on a securities exchange, stock exchange, they have to be settled at some point, and people usually don't think about it. But as you said, they take time for this. So now it's T+2. So from the day you enter the transaction until then, 2 days, and they want to reduce it to T+1. They think like it's a big improvement, but in crypto it's real-time settlement, right? And there's also a whole structure, a whole architecture, a post-trade architecture below the exchange that deals with this settlement, first clearing, then settlement, that falls away. And it's through the blockchain, it's a disruptive technology, and disruptive technologies also always make some people superfluous. And here, in my view, it's the CSD is no longer necessary, and the long chain of intermediaries is no longer necessary. You typically have only one intermediary and a chain, and all the assets are on this chain, which everybody can, it's completely transparent, everybody can see who holds what, and everybody is connected with everybody, which makes things much simpler and much nicer. And not less secure, but more secure than in the old world. That's people need to understand that. I'm always a little bit jiggling when I see that the CSDs, they want to use blockchain. But blockchain is there to get rid of the CSDs. We don't need them anymore. But they pretend, okay, we want to adapt to this world and also use blockchain technology, but they will no longer be necessary. So I think this is a very different thing. You have to conceive of it very differently. Yeah, that's why the European legislator also introduced this DLT pilot regime, because the financial regulation is based actually on this model of centralized depositories and intermediaries and so on, and doesn't take into consideration this new way of doing it. So I think it has a lot of repercussions that we are still figuring out.
It's definitely two different worlds. I found one thing that Christian said earlier struck me, namely, you highlighted the trustlessness of the system, and then at the same time said the intermediaries, well, they are parties that I need to put trust in. And I found it interesting that you have this dichotomy of trustless system and at the same time the intermediate that needs trust, who deals with these crypto assets. And I would like to address the next question, perhaps to Philipp again, from a practical point of view. What do you do as Bitpanda to, I don't want to phrase this question too generically, to build trust, but I mean, what I mean in specific is, do you need to file with the regulators, the addresses where you hold your crypto assets? Do you need to show them that they are actually there? Do you need to provide them with audit reports? What, in this sense, what do you do as a, generally speaking, as a CASP to establish this trust?
So basically, there are, MiCA has some rules about custodian services. And first of all, what you do is, and that's the same basically for bank, you build a multi-layered system on how you do custody. And that means you have a first line who does things, you separate ideally transaction and infrastructure, then you have a second line who checks those first line, then you have a third line who checks the other lines, and then you have an auditor, and all of these those reports that you then show to everybody. So that's actually pretty much that. All of these cases, all this governance works there. On a more direct level, what you do is, and what's quite interesting, that the FMR, as explained, and other supervisors are actually able to see where you store them because it's on a chain. And basically, they sometimes come up and say, "Hey, show me your wallet," and say, "You probably know them, but you want to know if I have new one. Happy to support you there." From that perspective, so that isn't as much. Let's say that in the supervisor, it isn't as much a problem, a topic. Mostly because, and that's the whole financial sector, it's a trust-based system. And I don't want to kind of think, you don't know if your bank has your money. Actually, you don't, because they probably only have 10 to 12%. But even that you don't really know, and the FMR does neither. Because the FMR comes to them and might ask them, and sometimes they are worse, like a case in Austria in Burgenland, if you might know, where they for years didn't have even close that amount of money and nobody knew. In this case, this system is way more transparent, as they can at least look at the chain if the things are there. So coming back, trust is earned by doing a good job, by following up through on the pay-ins and payouts, basically having great procedures that you work with your regulators. But we should never consider that the FMR or all the supervisors are actually not there to find if we do fraud. That's basically not their job.
Yeah, I mean, the blockchain is definitely transparent, but I mean, at the same time, you need your private key. There's a saying, not your keys, not your coins. And perhaps, Christian, now from a practical point of view, or from a point of view of what the Austrian law provides, how do I enforce my claim if I don't know the private keys?
Well, the approach the Austrian law takes is the only one you can really put pressure on that could give you information is in the enforcement as well as in the insolvency state the debtor as such, and you have the possibility, be it by an order of the enforcement court or by an order of the insolvency court, to force the debtor to give you the information regarding the key. But if, irrespective of these orders and irrespective of fines imposed on the debtor, doesn't give you the information, this is where the story ends. So in the end, there is a mechanism, but the effectiveness of the mechanism very much depends on whether you have a debtor that is willing to cooperate or that can be forced to cooperate by fines. If there are endless, funds in the enforcement stage, this would probably not be enough.
Would you have a suggestion on how to do it better? I mean, also perhaps from looking into other jurisdictions, and also Matthias, feel free to chime in. Do you see other jurisdictions do it better?
Well, from a policy perspective, you could think about some requirement to register the key somewhere.
Okay.
But I haven't seen that kind of system, and I think already the Austrian system, on a comparative law basis, is quite efficient. But I'm not aware of any more efficient ways to get information.
That has actually been suggested to have a registration system for the keys. I think it's in the Global Code on Enforcement, Digital Enforcement. But I don't think this is going to work either, because if you are not willing to cooperate in enforcement, why would you in the first place register your keys? I mean, if you are a recalcitrant debtor and you want to hide your crypto, you will not register it anyway. So I don't think that's really an alternative. The English courts have been quite innovative in using the tools that they have through the common law to go after these assets and go after debtors, because they have things that we don't have in Austria. They have, for instance, they have the possibility to bring claims against persons unknown. Mm-hmm. So you don't have to name actually if somebody stole your crypto, then you bring an action against a person unknown. Okay, you may think, okay, what's the point if I don't know this person? Well, it serves as a vehicle, because you can then also issue a freezing order to a custodian where you think, where you have traced the asset to. You don't know who is actually this client who holds the cryptos there with this custodian, but then you can bring this disclosure order that works on a worldwide basis. They give themselves the power to issue them on a worldwide basis, even to custodians anywhere else on the globe, and say, if you don't comply with this, it's contempt of court. And the custodians, I don't know whether Bitpanda also does this, but they typically cooperate and reveal the identity of the client, and then you have the other party to the lawsuit. Mm-hmm. So, and what I find interesting is the English courts do this to attract more business. So they interpret their rules of jurisdiction in very wide fashion to say, okay, if somebody comes to us and he says, I have I'm living in England, so they can bring these claims against anybody around the world. That generates a lot of business, and currently English courts are interested in generating more money, perhaps also different attitude to our courts, and they have made themselves into a crypto litigation venue, have clearly an edge over other countries about this, and I think we need to watch this carefully because there's a risk that they may dominate this space in the future.
Yeah, and I think it's also really, really interesting if multiple countries, try to do that, and then perhaps their courts order or issue different orders or contradicting orders, because then obviously the question is which order will you follow, if any? And I mean, Philipp, from a practical perspective, have you received any such orders?
So we receive a couple of orders every month around. Luckily, they were not contradictory, but we do have sometimes with foreign nationalities and police enforcement, and what we try to usually do is to cooperate, especially with our own, and kind of find a way to have everything aligned with them so that we don't have anything that goes against our national, which is usually, of course, the most practical way, because the police in Austria is here, so they have a way more clear way to enforce us, and they do understand when others need something and they cooperate with them. So usually we have always found a way that everybody kind of comes to one conclusion what to do correctly. We are quite in the sense cautious for all approaches, especially in basically not giving out too much of client information if not needed, but also of not letting the customer transfer things out. If there is contention.
Okay. I mean, so far we have only discussed the question of enforcement. We have not really spoken about insolvency, right? In the chapter that I wrote for Austria, one of the things that I discussed or that I tried to present is that you need to differentiate between different crypto assets, right? So if I think of Bitcoin in terms of insolvency, I don't really have to fear that Bitcoin as a system is going to become insolvent simply because it's fully decentralized and there's enough people who operate it. On the other hand, if I think about an exchange can become insolvent. And we've seen this a couple of years ago. Well, we've seen this number a number of times. Perhaps let me once more start with you, Philipp. Have you seen clients to come to Bitpanda because they need to flee from other exchanges, have perhaps had their assets be part of an insolvency? Do you have any first-hand experience about how those people were able to recover their assets? Just again from a practical perspective.
So the days around FTX has been about one of the busiest coming up to trading and transferring venue. So basically people, we had like two movements. The one movement where people kind of getting scared overly, but we had an even bigger movement of international people coming and transferring to us because FTX kind of helped them understand that what it means to be an exchange in a country they don't probably know where it is and they don't know the jurisdiction. So a lot of them kind of really sent them home and sent it to us and said, okay, let's go with the local player where I have them in there. From in insolvency character, we do see that it really depends on case by case. So we have seen FTX sometimes, and you can read the reports. They have been quite lucky because they got at least some value of money. I mean, they still weren't unhappy, but that is mostly because FTX they guy actually made some very lucrative buys of firms that later on became very, very wealthy, and that money was then enough to at least give them the old value, which was way less than the current value, but still something in there. In others, when we saw the Bybit hack, actually, that was where they just basically accepted the loss and didn't come back to the client. So it really depends on a case by case basis what happens, and so clients have the choice now, especially with Mika, that okay, either I have it as a custodian, I do it myself. But doing it yourself is not always the best solution either. I mean, you might know the cases of those who throw away a hard drive or something like that, or lose access in some kind because the only stick they gave it to it failed. So I would rather say their choice to be at a custodian is the choice made by most of them. And now in Europe it's easier because I can have more trust and I have more regulation on it.
Right. Okay. Matthias, perhaps I got a question for you. I know your one of your areas of expertise is international private law, and I mean, just generally speaking, who knows where my Bitcoin are stored? I mean, they are stored on the ledger of every full node operational out there, and I mean, I said Bitcoin is not going to become insolvent so quickly, but other players in the crypto field might. And I'm just curious, since I know you have worked on international law questions on that, what would you think is, what's unclear still? Let me phrase the question very open.
Everything.
What's unclear in the area of private international law, Christian says everything, and I think he is right, basically, for many jurisdictions, including this one. So Austrian private international law doesn't have any rule on this, which law applies to crypto, and in private matters. And we have like I think 2 doctoral theses and 3 articles, and everybody has a different opinion. So no court case. So you can only guess which law they would apply. I've worked a little bit with an international organization called UNIDRA in Rome, where we worked on the international harmonization of law, and we also made a specific recommendation for a private international law rule. And that could be used as a model if the Austrian legislator wishes, or the EU legislator wishes, perhaps. And there we suggested that in the first place you should be able, if you are operating such a network, if you're creating this, if you're programming this, to include a choice of law for the whole network. Or even for, if this is allowed under the rules of the network, for the individual asset that is transferred. Mm-hmm. Now, we all know that this is not going to happen. It's very unlikely that we will see that in Bitcoin network there will be a choice of law clause. Would be a little bit antithetical to the whole goal of being without law and without lawyers. But then we have subsidiary connecting factors. If there is no choice of law, we have suggested, for instance, for token, we could use the seed of the issuer. Mm-hmm. It's readily ascertainable. And for custodied assets, we can use the law that is agreed in the custody agreement. And I think from the industry perspective, it's already like this, that you think you are administrating probably the assets under Austrian law that you have. So a Bitcoin that you hold with Bitpanda would then be an Austrian Bitcoin, following Austrian rules. And we think this is a really good compromise, mm-hmm. because what other factors do you want to use?
Mm-hmm. Christian?
And does this suggestion also extend to the insolvency scenario? So this is then, and would you say this is in line with the current regime we have under the European insolvency regulation? Well, it doesn't really it doesn't really contain a conflict of laws, but it just says that that security rights remain unaffected by the insolvency, which leaves it
in another country.
if they're in another country, so which leaves it open. But I would be interested: does this provision you have developed also apply to the question whether the investor has is an unsecured or secured creditor or has a segregation claim, or would you say this is something that is more insolvency related?
Insolvency. So it has also specific insolvency rules, and I guess that would fall under the insolvency rules. It's more to do with pre-insolvency or outside of the insolvency. I acquire something which law governs that. And it's great that you mentioned it's Article 8 or something, insolvency regulation, where the assets that are outside of the country. I think we have to do a new article on that, whether it can be applied to crypto assets that you hold with an intermediary outside of the country of insolvency. That would be very interesting. It's a great idea.
Yeah, but perhaps Christian, there's a lot of things yet unclear, but I would assume at least if insolvency proceedings are opened up, on the assets of an Austrian debtor, it would be clear that any crypto assets they have, however you define have in this regard, would fall into the estate, right?
Yeah, that's in my view crystal clear. Yeah, I agree with that.
And then just the question is, what do you mean by have? What if people share a private key, for example?
I was very amazed by what Philipp told us about, the information you give authorities. This would, of course, also be very interesting and helpful, I think, for insolvency trustees who have to realize these assets, because for them, of course, it's a big risk. At what point in time do I sell? If they are unfamiliar with this type of assets, of course, they could use experts, but if I understood you correctly, you're very cooperative when it comes to dealing with authorities.
Absolutely, and I think that's one of the key aspects, especially as we shouldn't forget this is sometimes very localized. We are not speaking about like the one for Germany, the one for Austria, so we are talking about a small police force somewhere, and that means they might have had to do with that in the past or might not have to do with that in the past, and then you kind of really need to kind of educate them and show what their options are there, and we try to kind of have the best result for all sides element. And I think just coming on the back thing, and the most important thing, of course, is the whole segregation at the end of the day, because that's the assets. Hopefully also for the others, but for ours, I can make sure the assets are here, and then should anything happen, then you have a segregated claim, as you have in the whole investment world.
Mm-hmm. I mean, it's a fascinating discussion, but also good things have to come to an end sometime. But before we stop, I would like to give everybody the opportunity perhaps to, just tell the audience, either here or at home, what, any important message that you think would be worthwhile, perhaps as a replacement for, closing remarks by everyone. Christian, would you like to start?
Well, thank you so much. I think this brief debate we had today shows that there is so much room still for, academic work and fruitful debate between academia and practice. So I'm very thankful, and I hope there will be many. We just had an idea about a new article, so we will have to pursue that. And I'm very grateful for the invitation. Thank you so much.
Matthias?
My summary, and also from last research I did, is a little bit, we have to get away from the idea that the traditional financial system is completely centralized and the new one is completely decentralized. I think we have different waves of centralization and decentralization. Also, now in this space we have centralization with some intermediaries, but in a very different form, right? So you have to be careful. It's a global asset, but at the same time, and you mentioned it's also a localized asset And people may prefer, for very good reasons, to hold them locally with a local intermediary, and then we have a lot of local questions that we have to deal with, but in a new setup. And I think that's the fascinating thing. It's hard to compare with the old one, and that makes all the challenges.
Mm-hmm.
From a practical point of view, I'm really looking forward to more work on this. We are always looking for guidance from academia, lawyers, lawmakers on how to proceed this. As these assets are used more and more people have them. At the end of the day, they have more and more cases that the life gives them. And that means we need to have answers on how to work with them, be it a criminal case or a personal case, and probably in the future also more on kind of inheritance and all of these kind of things. We will need to give answers in these complicated cases, and we're always looking forward to this kind of work.
Yeah, I mean, I really do think crypto is international, the blockchain is international, and at some point what's really, really important is that academia and the practice, from not just Europe but all around the world, finds a common ground and a common language to discuss this matter. So if I as a practitioner can, contribute a little bit, then I'm also very grateful for that. Thank you so much for this really, really interesting panel. I'm really glad that you were here. Thanks everybody for listening and for watching, for everybody who's at home. And so I'd like to close this panel. And for everybody who's here, I'd like to open the buffet right now. Thank you very much for coming.
Thank you.